Commercial and residential real estate ownership is rarely static. A storefront might house a bakery one year and a tech repair shop the next. Every time a property is leased or assigned, a complex web of legal obligations is created between current and former occupants. To see these mechanics in practice, we must trace a specific chain of title. Jamil recently purchased the freehold of a two-story building from Ian. The property consists of a ground floor shop and a residential flat above it. Before selling to Jamil, Ian granted two distinct leases. In 1995, he leased the shop to Mary. More recently, he leased the flat to Rebecca. Both tenants subsequently assigned their interests. Mary assigned the shop to Fred, and Rebecca assigned her flat to Sonia. Now, 3 legal breaches have occurred simultaneously. Fred converted the shop into a repair outlet without permission. Sonia allowed the flat's internal doors to fall into disrepair, and Jamil failed to fix a cracked exterior wall. We must determine which parties have the legal standing to bring a claim. Can Jamil sue Mary for Fred's unauthorized conversion? Can Fred sue Jamil for the structural failure of the wall? Resolving these claims requires a distinction between the lease as an estate in land and as a binding contract. Because a lease creates 2 separate legal relationships, the right to sue depends on which relationship is being invoked. Every analysis begins with the date of the lease grant. The Landlord and Tenant Act 1995 established a demarcation line on January 1, 1996. Leases granted before this date are old tenancies. Those granted on or after it are new tenancies. The ground floor shop lease was granted to Mary in 1995, making it an old tenancy. Consequently, it is governed by the Law of Property Act 1925 and historical common law rules. Between the original signing parties, there is privity of contract. This contractual relationship persists for the entire duration of the lease term, regardless of whether the parties assign their interests or sell the freehold. Because of privity of contract, Mary remains liable for the tenant covenants for the full term. Even though she assigned the lease to Fred, Jamil retains the legal right to sue Mary for Fred's breach. However, Jamil also has a relationship with the current tenant. Jamil and Fred share privity of estate, which allows for the enforcement of covenants between the current owners of the lease and the reversion. Under the rule in Spencer's case, privity of estate only transfers the burden of a covenant if that covenant touches and concerns the land. Courts identify whether a covenant touches and concerns the land by applying the qualitative test set out by Lord Oliver in P&A Swift Investments. The test stipulates that a covenant must benefit only the reversioner for the time being and must affect the nature, quality, or value of the land. It cannot be purely personal to the original parties. Fred's covenant restricts the property's commercial use. Because this restriction dictates how the land is utilized, it directly affects the nature and value of Jamil's reversionary interest. The covenant satisfies the P&A Swift test. Therefore, the burden passes to Fred under Spencer's case, and Jamil may sue Fred directly for the unauthorized conversion. We must also address Jamil's liability for the cracked exterior wall. Under Section 142 of the Law of Property Act 1925, the burden of a landlord's covenant passes to the assignee of the reversion if it has reference to the subject matter of the lease. Structural repair meets this definition, making Jamil liable to Fred. When analyzing old leases, the most frequent error is neglecting the original tenant. Mary's privity of contract means she remains liable to Jamil even decades after she has left the property. The residential flat is a new tenancy because it was granted after January 1, 1996. This means our analysis shifts entirely to the framework of the Landlord and Tenant Covenants Act 1995. The 1995 Act changed the law specifically to prevent the perpetual liability we saw with the shop lease. It focuses on releasing tenants from their obligations once they assign the lease. Section 5, subsection 2A of the Act mandates that a tenant is automatically released from the tenant covenants upon a lawful assignment of the lease. Applying Section 5 to our scenario, Rebecca was released the moment she assigned the flat to Sonia. Jamil has no legal standing to sue Rebecca for the broken internal doors. Instead, Section 3 of the 1995 Act dictates that the benefits and burdens of covenants pass automatically to the current assignees. Crucially, Section 3 does not utilize the touch and concern test. All covenants pass to the new tenant automatically, unless the lease expressly states the covenant is personal. The interior repair covenant is not personal. Therefore, the burden passed directly to Sonia. Jamil's claim for the doors must be brought against Sonia alone. Landlords can mitigate this automatic release through an authorized guarantee agreement, or AGA, under Section 16. An AGA allows a landlord to require the outgoing tenant to guarantee the performance of their immediate successor. However, the guarantee expires once that successor assigns the lease again, preventing the return of indefinite liability. Note that for post-1996 leases, citing Spencer's case or the touch and concern test is a technical error. The transmission of covenants is now strictly statutory. Identifying who can sue is the first step. The second is determining the correct procedure for extracting a remedy. The law applies different procedural rules depending on whether the landlord is seeking rent or a remedy for a non-rent breach. To recover a fixed charge, such as rent arrears, from a former tenant under an AGA or Privity of Contract, the landlord must comply with Section 17 of the 1995 Act. Section 17 requires the landlord to serve a default notice on the former tenant within 6 months of the charge becoming due. If Jamil misses this 6-month window, his right to claim those specific arrears from a former tenant is lost. Conversely, we must look at the tenant's right to withhold rent if the landlord fails to perform repairs. Fred may be tempted to stop his payments until Jamil fixes the cracked wall. However, at common law, a landlord's breach of a repairing covenant does not automatically grant the tenant the right to withhold rent. To legally withhold rent, the tenant must meet the requirements for equitable set-off established in Taylor v. Beal and Lee Parker v. Ivet. Fred must notify Jamil of the repair, allow a reasonable time for performance, and then perform the repairs himself. Only then can he deduct the specific liquidated cost from his future rent. If a tenant stops paying rent without following this procedure, they become vulnerable to forfeiture under Section 146 of the Law of Property Act 1925, which allows the landlord to terminate the lease prematurely. The 1995 Act transitioned the legal framework from a system of perpetual contractual liability to a model of rolling statutory responsibility centered on current occupancy. You can navigate any assignment problem by following a definitive 4-step checklist. Step 1. Determine the date of the original lease grant. This dictates whether you apply the 1925 Act and Spencer's case or the 1995 Act. Step 2. Identify if the covenant is express or implied. Step 3. Apply the correct transmission rule. For old leases, test for touch and concern. For new leases, apply the automatic transmission under Section 3. Step 4. Select the appropriate remedy and check for procedural hurdles, like the 6-month notice requirement under Section 17. Precision in statutory application, rather than general arguments of fairness, is the only way to successfully navigate the anatomy of an assignment.